Hello, good morning, everyone. Welcome to this third table of the 7th International Congress on Constitutional Law about equality and non-discrimination from the Center of Constitutional Studies of the Supreme Court of Justice. Today, we are going to talk about affirmative actions. As you know, people who have attended this Congress, the previous sessions, those who are in Facebook and in the platform of the Supreme Court, you can ask your questions through the icons of each one of these platforms. Likewise, I'd like to tell you, the people who want to listen to this broadcast in English, you may do so through the website of the Center of Constitutional Studies, and we will broadcast live in our Facebook website. Well, having said this, I'd like to introduce the people who are with us today, professors, to talk about affirmative action. First, we will listen to Kasper Lippert-Rasmussen, who is political theory professor of the Political Science and Government Department of the Business School and Social Science of the Aarhus University. His research includes ethics, applied ethics, normative ethics, social philosophy, and political philosophy. He's the author of several books, among them Relational Egalitarianism and the Ethics of Discrimination. Next, we are going to listen to a professor who has participated in our programs and several events and publications of the Center of Constitutional Studies. I'm talking about Roberto Zaba, who is professor of the Law School of the University of Buenos Aires and also the Law School of the Palermo University. His research includes the analysis of the equality principle within constitutional law. He is the author of several books, among them Constitutional Supremacy and Private Law, Structural Inequality and Affirmative Actions, and the principle of equality in the dialogue in international and constitutional law. Without further ado, I'll give the floor to Professor Lippert-Rasmussen. Professor, thank you very much.
Well, thank you so much for the invitation. So I'll just share my screen. To be honest, I was not sure exactly how much I could do in these 20 minutes. So basically, what I'll do is to say a bit about what affirmative action is. And then I have 3 points in relation to affirmative action, which I would like to get across, and then I'll stop. So what is affirmative action? So here's a kind of influential definition, which says that something is affirmative action if and only if it amounts to positive steps taken to increase the representation of women and minorities in areas of employment, education, and culture from which they have been historically excluded. So that's a definition that you find in Stanford Encyclopedia of Philosophy. Interesting here is, among other things, the notion of positive steps. So presumably there are steps that are not positive. And I assume that those are steps that simply eliminate direct discrimination or the effects of direct discrimination on part of the affirmative action agent. So positive steps go beyond that. Positive steps go beyond simply, for instance, eliminating the hiring companies' bias against minorities or whatever. Also, it's notable that affirmative action aims at increasing the representation of women and minorities. You could ask whether you could have affirmative action in favor of men, say, in areas where they have historically been underrepresented. Also, you could raise questions about whether areas of employment and education and culture are the only areas where you could have affirmative action. So perhaps in healthcare, you could imagine having affirmative action as well. And then finally, you might also ask questions about whether those who benefit from affirmative action necessarily have to have been excluded from the areas in which they benefit. So even presumably not all members of minorities have been excluded from a particular area. If you take steps to increase the representation of minorities by including some of those members who have not been excluded, would that count as affirmative action? But these are all details, and I think if you're interested in the concept of affirmative action, you need to go into these discussions and many others. I think the basic takeaway point here is that affirmative action is action that aims at increasing the representation of groups of people that go beyond simply eliminating direct discrimination against these groups, or eliminating or mitigating the effects of direct discrimination against these groups. So with that conceptual question behind us, and I want to ask if affirmative action is morally justified. And I won't give anything like a comprehensive answer to this question. I will simply make 3 points in relation to whether affirmative action is morally justified. And I should remind you that my background is not in law. My background is in ethics. So the question I'm asking here is a question from the point of view of ethics. So the first point is that affirmative action are many different things. So, for instance, you could distinguish between affirmative action that set quotas versus affirmative action that simply set goals, but do not set aside places for members of minorities. You could also distinguish between strong and weak forms of affirmative action, depending on how strong a preference they give for people who belong to minorities. The weakest form of affirmative action says that if you have, say, equally qualified candidates, then it's permissible to give automatic preference to minority applicants. And finally, you could also distinguish between exit and entry-based affirmative action. I think most discussions of affirmative action focus on entry-based affirmative action. But if you, for instance, take the issue of gender representation, it's actually a natural thing to focus on exit-based affirmative action as well. For instance, in Denmark, this would involve making it more attractive for older people to retire, where older people will typically be men and newly hired typically will be women. So you could also distinguish between different dimensions in relation to the justification of affirmative action. So one thing you could ask is, what exactly is the alternative to affirmative action? So presumably whether you can justify affirmative action depends a lot on what the alternative is. Is the alternative status quo? Is the alternative some kind of compensation to excluded minorities? Secondly, you could also distinguish between instrumental and non-instrumental justifications of affirmative action. So you might think, well, some people think that affirmative action on the basis of race, for instance, is non-instrumentally unjustified because it's always impermissible to treat people differently on the basis of race. But you could also raise questions about instrumental justification, that is, justification in terms of the consequences of affirmative action. You could also, and that's my third dimension, you could also distinguish between whether you're asking about whether affirmative action can be justified given that people respond in an ideal way to affirmative action, as opposed to a non-ideal way, because it might be the case that, say, some people, suppose that you have an affirmative action program, and some people unjustly respond in certain ways to the existence of such a program. Then it might be that the program is justified from an ideal point of view, but it's not justified from a non-ideal point of view, where you take for granted that other actors will respond in unjust ways to the existence of affirmative action. And finally, you can also ask about whether, when you talk about justification, you talk about justification in relation to justice, or whether you talk about justification to all other values that might bear on affirmative action. So I take it, for instance, that welfare might be another value which we also need to take into consideration when assessing whether more affirmative action is morally justified. So these are a lot of distinctions, but my basic point is simply that the question, is affirmative action justified, is a bit like the question, is foreign policy justified? I mean, if this comparison works, then it presupposes that you find it a bit difficult to say what you want to answer in response to the question, is foreign policy justified? And actually that you would most likely respond to such a question that it all depends on what particular kind of foreign policy you are asking about. So I would say that it's the same with affirmative action. Some instances are justified, others are not, and it's quite a complex issue. And the question, is affirmative action justified, is asked at a too general level for it to allow for a meaningful yes or no answer. And that's actually a point I make in the book, Making Sense of Affirmative Action. So that was my first point. I now want to look at two objections to affirmative action, which I think are misplaced. And I should say in general that I think a lot of arguments that have been offered in favor of affirmative action or against affirmative action are not particularly convincing argument, and often take us in quite different directions. At least from the context I know, probably the most common objection to affirmative action is the objection that affirmative action simply is a form of discrimination, a reverse form of discrimination, in the sense that those who benefited from it are those who typically are the victims of standard forms of discrimination, and for that reason is wrong, because any form of discrimination is wrong. So here's a way of putting this objection in a slightly quasi-formal way. So the objection has three premises. The first one says affirmative action involves treating people worse than others simply because they have certain morally irrelevant properties. So that's the first premise. Treating people worse than others simply because they have certain morally irrelevant properties is invidious discrimination. Invidious discrimination is unjust. Thus, affirmative action is unjust. Now, I think it's interesting to assess this argument, and basically I'm going to argue that that's a very bad objection to affirmative action. I don't have anything to say about the third premise, invidious discrimination is unjust. I take it to be kind of analytically true, but I do want to say something about the first premise, because I think if you're a friend of affirmative action, or a particular affirmative action scheme, say favoring women, you might say that that scheme does not involve treating men worse than women simply because they have the property of the gender. Rather, you would say that true, it involves treating men worse than women, but that is because women historically have been excluded, and one way of addressing that situation is by, say, giving extra points to female applicants or whatever. So I think in order for the first premise of the argument to be true, you have to substitute it with a weaker premise, one which says, one which says affirmative action involves treating some people worse than others because they have certain morally relevant properties. And the change here is that we no longer say simply because they have certain morally relevant properties. But if we do that, we also need to change the second premise of the argument to retain validity of the argument. So we would now have to say treating people worse than others because they have certain morally relevant properties is invidious discrimination. The problem now is that we now have a valid argument, but the problem is that this weaker version of the second premise is false, or at least it begs the question, because people who subscribe to affirmative action would say that they would simply deny what premise 2 star says. In their view, affirmative action, which does involve treating some worse than others because of certain morally relevant properties, is not invidious discrimination. And also, they could appeal to the fact that there are cases where people do think that it is justified to treat people differently on the basis of, say, properties like gender. So if you have a home for battered women, it is permissible for such a home to treat people who want to enter the home differently because of their gender. Of course, it's true that you're not treating them differently simply because they have different gender, but you're treating them differently because they have different gender. So I would say that this reverse discrimination objection to affirmative action is not a good objection. And in the interest of time, I would say something more about a more sophisticated version of the reverse discrimination objection, but I'll skip that and then move to my third and last point, which is about the stigma objection to discrimination. So this is a different kind of objection from the reverse discrimination objection, because the reverse discrimination objection basically says that any form of affirmative action scheme is morally unjustified. The stigma objection says that forms of affirmative action which stigmatizes its beneficiaries, its intended beneficiaries, are not justified. And actually, there's an American philosopher who's articulated a very strong version of this objection. It says, if some demon had sought to concoct a scheme aimed at undermining the credential of minority scholars, professionals, and students, to stigmatize them permanently and humiliate them publicly, no more ingenious plan could have been devised than the system of preferences now defended as a social need and great favor to minorities. And he's speaking about affirmative action on a racial basis in this case. The stigma objection to affirmative action, again, we can represent it as follows. Simple argument, 2 premises. The first one says, affirmative action stigmatizes the group that are its recipients. And the second premise is that there's a significant moral reason against engaging in any action which stigmatizes a group. Thus, and that's a conclusion, there's a significant moral reason against engaging in affirmative action. So basically, the idea is that to take affirmative action in favor of women in connection with university admissions. So if you, say, require lower score points in order to admit a female applicant than a male applicant, that will stigmatize female students because they will be seen as not as qualified as or academically talented as male students. That's the idea. Now, one thing I think one needs to ask about this first premise is whether it's really true that all forms of affirmative action stigmatizes beneficiaries. So one form of affirmative action is what you call outreach affirmative action, where you, so to speak, in the application phase, you treat all applicants on the basis of the same criteria, but you make special efforts in the phase prior to the application phase to make sure that minority applicants apply, or you might even make special efforts to train minority members who might potentially apply for the job in question. It's not so clear that this will actually stigmatize minority members. But I think there's another issue which is more central to the assessment of this objection. And that is what exactly stigma, what's the nature of stigma? And here I would want to distinguish between two conceptions of stigma. And what I'll call the naive conception of stigma, the empirical basis of stigma is completely rational. That is, a certain group is stigmatized as being, say, less academically talented. If it's a rational statistical inference to make on the basis of the assumption you have, and otherwise not. It's objective in the sense that whether or not people are stigmatized in this way does not affect the matter about which the stigma is about. So there's no such thing as a stereotype threat, for instance. And also it's fully cognitive, involving full-blown beliefs and not, for instance, various kinds of emotions or irrational dispositions. And I'll contrast this with what I'll call the realistic conception of stigma, which is that simply the negation of each of these three components in the naive conception of stigma. And basically that's a conception of stigma that's informed by a study in social psychology, according to which stigma is far from based simply on rational inferences, rational statistical inferences from available evidence, but things like personal experience plays a large role, a much larger role than it ought to play in relation to whether or not you think of people as academically qualified compared to, say, statistical information. And also, people tend to see causal relations where they only have correlations. So if, for instance, it turns out that there's an overrepresentation of men among professors, and there's a bunch of good explanations of why that is so, where you don't necessarily ascribe any causality to this, nevertheless, people will tend to see it as such. In any case, the problem here is, and I think this will be my last slide, is that I think there's a dilemma here for the for the stigma objection, which is that either the naive conception of stigma is true or it is not true. If it's true, then premise one in the stigma objection might be true. Just to remind you, the premise one in the stigma objection says that affirmative action stigmatizes the groups that are its recipients. It might be true if the minority group here refers to minority recipients of affirmative action. So if we're talking about this in the context of university admission, then we would be talking about minority students and not minority people in general. However, for the second premise in the stigma objection to be true, it must refer to minority people in general, and on the naive conception of stigma, they are unaffected by affirmative action. So basically what I'm saying here is that if you, say, have an affirmative action scheme in order to admit more women at university, then that might give you some rational reason to infer that the average female student might be less academically talented than the average male student, given a lot of assumptions. But it will give you no reason, no statistical reason to think differently of women in general compared to the situation where you don't have that scheme. And it's not clear that one should be especially concerned about whether female students are stigmatized compared to women in general. So if it's alternatively the case that the realistic conception of stigma is true, then premise one in the stigma objection is likely to be false, because a result of affirmative action is probably that people will see more minority people in the role of experts, etc. And according to the sheer numbers effect, that is, a person simply on television or whatever see minority people in the role of experts, will result in a reduction in the degree to which minorities are stigmatized. So just to conclude, on my third point, I think we have to be very careful before rejecting an affirmative action scheme on grounds of the stigma objection. So these were my 3 points in relation to affirmative action, and I think I should stop here. Thanks a lot.
Thank you very much, Professor Lippert-Rasmussen, for your presentation. Without further ado, I'll give you Professor Roberto Zaba. Thank you for being with us this morning. Thank you very much, Diana. Thank you for the invitation. As always, it is a pleasure to take part of your activities. Today, sharing a panel with Professor Kasper Lippert. Well, I'll cut to the chase. I'm also going to continue with the line of Professor Lippert about the justification of affirmative action and the consequences and the effects of the different justifications. But I'm going to defend one specific justification that I think can be appropriate for constitutional democracies like Argentina or Mexico that set forth the principle of equality in their constitutions, and also aligned with the recognition of equality in the American Convention on Human Rights and the interpretation that the Inter-American Court has made of this principle that we find in Article 24 of the Convention. Well, firstly, I think I have to say, what is affirmative action? Even though Professor Lippert already explained that during his presentation, I'm only going to remind you that when we talk about affirmative actions, we are thinking in measures or policies, either state policies or by individuals that give a preferential treatment to certain people due to their belonging to certain groups in certain conditions. So we are talking about, I would say, a species in the genus of preferential treatment, either from the state or from individuals. I'm going to focus on the state specifically. So the question would be, how can we justify that the state can give a preferential treatment to some people by virtue of their belonging to certain groups? Well, as you can imagine, from the definition of affirmative action, we have common arguments against the implementation of these measures or policies of preferential treatment, among them affirmative action. One that was already mentioned by Professor Lippert is the objection that says that affirmative action, since it is a preferential treatment to certain people, could be in conflict with the principle of equality. We will talk about this in a few minutes, but constant objection is that affirmative action is a form of discrimination, as Dr. Lippert said. Another common argument against these measures of preferential treatment has to do with comparing these measures with rewarding merit. So the attempt is to reward merit just as it affected the reward of merit. So bearing in mind these objections, I think that we have to make an effort to justify affirmative actions. Why? What are the foundations that justify the implementation of affirmative actions by the state? In terms of justifications for affirmative actions, we have a wide range. Many authors have tried to justify it differently, and I'm going to mention two, at least, that are very sound, very recurrent, but they are going to be different, not necessarily contradictory, but different to the one I'm going to defend later. So these two examples of justifications are as follows. Number one has to do with the fact that affirmative actions or preferential treatments to certain groups are required, but with the purpose of the institutions where these affirmative actions take place. I'm going to give you two examples of this thesis. One, for instance, an example is affirmative actions in political representation bodies like parliaments. How do we justify from this perspective of the institutional purposes affirmative actions? Well, we need to turn to political theory, democratic theory, that underlies the purpose sought by the institution, like a deliberative theory of democracy that thinks that democracy is valuable, that because through public deliberation, we have access to the best possible decisions. Through that deliberation, we make the best public decisions. But in order to have a robust and rich deliberation, we need to have in that deliberation a diversity of standpoints, a diversity of perspectives with as much information as possible and with arguments of each possible decision. And this theory, the deliberative theory of democracy that expects the parliament to be one of these institutional spaces for these deliberations to take place, requires diversity and plurality of voices within the parliament. Therefore, for instance, like in Argentina and many other parliaments in the world, we saw that for decades, we didn't see women represented in these institutions. The percentage of political female representatives is lower than the population in certain communities. So that discussion, that parliamentary discussion where male voices prevail, is a discussion that we presume will not be as rich as a deliberation that has more women in the parliament. So we assume, I understand this can be controversial, but we assume that the diversity of voices sought in this deliberative process is not achieved unless we increase the number of women in parliament. It can be the case with indigenous peoples. I'm thinking about the Constitutional Assembly in Chile, that of 255 representatives in the Constitutional Assembly, 17 are for indigenous peoples. So in that deliberative process, we need the highest number of voices and plurality, and this can justify certain measures of preferential treatment, like quota of female representatives in the lists of candidates to parliament to achieve more diverse voices and better decisions. Another example of this thesis that links affirmative action to the end of the institution in which it is implemented is educational institutions like universities. Under certain educational theories or even theories about the education of citizens, like Amy Goodman's work in terms of education, democratic education, we understand that training like in high school or university will be better the more diverse voices we have, like in the classroom, among students, among professors and teachers. So the end in education that is the best education possible, and we think that the best education possible is achieved with more diversity in information and perspectives and arguments we have can be the justification for affirmative action measures to contribute to this diversity in classrooms or among teachers. So the first possible justification of affirmative action, how, well, as a means to achieve certain institutional purposes. Let's say the purposes of the parliament and the educational objectives of an institution. Another thesis to justify it is the one that understands that preferential treatment to groups who are in a disadvantageous condition is justified in the need to set off prejudices historically suffered. That is, there's a certain idea of this kind of justice. So these groups that were historically excluded or treated differently to be compensated with this preferential treatment. So they are quite different, whereas the first one was related to institutional ends. The second one looks to the past, towards the compensation for damages suffered by that group. Without debating these theories, I'm going to propose a third theory, which is linked to the constitutional recognition and conventional recognition of equality before the law. I understand that the way we understand or interpret the scope of the principle of equality before the law of our constitutions or the Inter-American Convention on Human Rights will justify or not the affirmative action measures or preferential treatment. Unlike the previous ones, we are going to see that a justification based on the principle of constitutional equality, I think, will have a broader reach compared to a thesis based on the institutional ends in which the measures are taken, because the theories that have to do with the robustness of democracy that justify the affirmative action is not the theory that will allow us to apply affirmative actions in other fields in which that thesis is not applicable. So I think that the thesis of affirmative action founded on the principle of equality can give us a broader argument than the thesis linked to institutional ends. Now, if I talk about the thesis about historical compensation, I think the thesis that is based on the principle of equality not only is looking at past prejudices of people who belong to certain groups, but also is looking for mechanisms to eradicate what put that people in that disadvantageous condition. So that's the difference with the second thesis, just to show you this debate around the justifications and how this justification I propose can be another justification based on constitutional and conventional premises. Since I don't have a lot of time, I'm going to be brief. The principle of constitutional equality can be understood in several manners, but there's a way in which we understand equality before the law that has acquired more importance in our courts and in non-discriminatory laws, and even lay people understand equality. And equality has been articulated with such level of details and sophistication like in our jurisprudence, and it has been translated into non-discriminatory rules, is what I call equality as non-discrimination. So this idea of equality as non-arbitrary treatment understands equality as opposed to any state or private treatment. Well, I'm going to leave individuals out of this, is a treatment by the state based on unreasonable or arbitrary reasons. Here, courts have used the notion of arbitrariety and unreasonableness. So when constitutions and international treaties on human rights talk about equality before the law, are telling the state if it's going to make a distinction between people, that distinction should be based on some reasonable criterion, and these courts are going to understand reasonability, how this links to the criterion and the end. If our end is to reduce the rate of car accidents, so driver's license can't be issued to men and not to women, because the gender of people does not have this relationship with the functionality of the end. So that's why it's arbitrary and it violates the equality before the law. Before this idea as non-discriminatory, so depending on the countries, and well, some jurisprudences have more years than others. In the case of the Inter-American Court, this has been the case for more than one decade. There's an interpretation of equality before the law that is different to the one I just presented as this much more consolidated vision and the legal articulation, that is the idea that equality, in fact, is linked not only with non-arbitrary treatment, but also with the need of dismantling structural inequality situations. What do I mean by this? Those situations in our political communities that put a group of people in a systemic and structural intergenerational disadvantageous position, we would have to delve into the concept of structurality of this inequality. But we see that social structure in which group of people are in a structural disadvantageous situation is incompatible and inconsistent with equality before the law. That is, a nation committed constitutionally with equality before the law can't tolerate a social structure of case. As the Supreme Court of the US says in the case of Hyler, it says the equality before the law is not consistent with a social structure of case. And what is that? Well, we are in constitutional democracies in the Western world, but Brennan talks about the situation in which there are groups of people who are in a structural disadvantageous condition, and its members can't do anything about it unless the state takes measures that dismantle that causes this structural disadvantageous condition. So see how these two visions of equality, I'm going to leave that for our conversation later, they are not strictly exclusive, they are not incompatible, but they are different to lead to two different positions with respect to affirmative action. If I understand equality before the law exclusively as a principle opposed to arbitrary treatment, any preferential treatment based, for example, on criteria like sex or race, this is what happens with affirmative action measures, would be in conflict with the notion of arbitrarity that is theory of equality that was developed through jurisprudence, because some anti-discriminatory measures in our country says that these criteria like sex, race, shouldn't be used to establish differences in treatment because they are unreasonable criteria. But see that affirmative action is founded on those criteria. So it isn't a surprise that those who defend or see equality before the law exclusively as an expression of non-arbitrary treatment reject affirmative action because they see in affirmative action as an arbitrary treatment. Nevertheless, the idea of equality as a non-subordination of groups and opposed to structural inequality, instead of countering these measures, will be required, because if it's not through these measures, the state will not dismantle the causes of structural inequality. So if I gave a title to this paper, I could say that are affirmative actions contrary to equality, or are they required? And I can answer this question without talking about the scope of constitutional equality. If it's understood as non-discrimination, then in affirmative actions, we are before arbitrary treatments. But if it's understood as non-subordination of groups and contrary to a social structure of structural inequality or case, so the state should use these measures to dismantle what causes the situation of structural inequality. I'm going to close with two remarks that I think are quite interesting. One is, what's the relationship of this thesis with certain designs of affirmative actions? For instance, in my country, for some years, there was a rule, a policy of preferential treatment for the access of women to parliament. So political parties should have at least 30% of women in their list of candidates. A few years ago, a political party proposed a list of candidates, men and women, and 100% were women. And the electoral authorities in our country didn't allow that political party to compete in the elections because they understood that the fact of not having men in the list was a violation of equality before the law. So overlooking that, affirmative action policy talked about a ceiling of 30%, of course, of a floor, not a ceiling, and 30% women in the list of candidates, not men. So the question we ask is a list formed by 100% women in a context of an affirmative action of 30% minimum for women violates the equality before the law because they don't have men in the list. can we say that a list formed by women only to Parliament violates equality before the law? The appeals court, our highest court in Argentina, before the Supreme Court, said no, this list couldn't compete. For me, this was a huge mistake. Well, the appeals court didn't understand that. First, affirmative action talks about floors, not ceilings. And number two, the way we justify affirmative action is in the fact that women were systematically excluded from political administration. We have no case in the history of Argentina of parliaments with a majority of women with no access for men. Men are not part of a group that has a situation of structural disadvantage. Another example that I think it's interesting, I don't know if it is still applied, but in the states of Coahuila and Veracruz, there was an electoral system that was debated at the courts that said that there couldn't be more than 70% of candidates of the same sex in the list for candidates to parliament. So see how interesting this was, because this measure is not an affirmative action measure in the sense of the preferential treatment, but rather a measure that intends the list to have a component of at least a ceiling of 70%. If we understand affirmative action as founded on the situation of the structural disadvantageous context of a group, there's no way to justify a ceiling of 70%. Because when I have a ceiling of 70% for one of the groups, or for both groups, I'm generating a quota for the group that is not in disadvantage. And that preferential treatment of the group that is not in disadvantage is not possible to found it on the idea of equality. So with that, I'm going to close with that. It's very interesting to have clarity on the sound foundations of the reasons why we implement an affirmative action or a preferential treatment policy, because the risk of making this type of mistakes, like the ones I mentioned in these examples, is very high. And the other thing is, how do these ideas translate into constitutional rules? Nowadays, with the Constitutional Assembly in Chile, we are discussing how the Constitution in Chile may incorporate an article about equality, but that isn't limited to the idea of equality as a non-arbitrary treatment, but rather incorporates the idea of equality as non-subordination of groups. That's it, but I look forward to our conversation on how to design a rule like this, and thank you very much. Thank you very much, professors, for your clear and deep presentations. And because of that, well, of course, we have little time left, but this is what I propose. Let's have these rounds of 3 questions. And let's see, well, we have like 45 minutes left. The people who sent their questions, thank you very much. I hope many of those questions can be grouped in what I'm going to ask our professors. The 3 first questions, if I had to label them, have to do with the concern for affirmative actions in deeply unequal contexts, that is, societies where poverty and inequality are imminent problems. So the first group of questions would be, how can we think about these affirmative actions in countries with such high poverty rates? In this context, what could be the criteria or the tools to prioritize needs and resources, especially with certain matters? Let's suppose that we've admitted that affirmative actions have a constitutional purpose and they are morally justifiable. Now, the problem would be the distribution of resources. So what do you think about this? Another version of the first question is if the affirmative action could give tools to governments to focus their actions or policies against inequality into specific and sectorial affirmative actions, but they do not address structural inequalities. So in that sense, thinking about actions and public policies, when we think about affirmative actions and their end, if one of their end is equality, equality of what? What do we want to be equal if that's the purpose of this type of interventions? And number three is a more empirical question on the effectiveness of this type of actions. Several people are asking that similarly with affirmative actions, we try to solve many things, like quotas are the answer to many problems of discrimination, exclusion, and inequality. Supposing that they are morally justifiable and these actions pursue legitimate ends, how this policy of quotas may solve inequality issues in an effective manner. So similarly, the question is, if you have data on this, if you know about studies in which affirmative actions were applied, and this had an impact on fighting discrimination and inequality. So this is the first block of questions. Feel free to answer as you wish. That is to prioritize as you see fit. Let's start with Professor Lippert-Rasmussen.
Okay, so these are just a few reflections in connection with the three questions. So I think one thing which is important to keep in mind is that affirmative action need not stand alone. So if you face problems about severe poverty, or as Professor Saba talked about structural injustice, the thought need not be that affirmative action, so to speak, is an instrument that on its own can be used to solve problems about poverty or problems about structural injustice. So it might be an instrument in a box that contains other instruments as well, and it's no good objection to affirmative action that on its own it's an instrument and cannot solve all the problems. Specifically in relation to poverty, I think that in effect, affirmative action programs sometimes have been programs in favor of people who, to a larger degree, encounter poverty than people from other groups, but often on, say, grounds of caste or grounds of race. But I guess in principle, you could have affirmative action schemes that directly targets poor people. So you could have, say, if we're talking about university admissions or hirings in the central government, you could have affirmative action programs that give special points to applicants who come from a poor background, whose parents earned below a certain amount of money. I don't think actually that there are very many affirmative action programs that specifically targets poor people, but that might reflect my limitations of knowledge. But in any case, I don't see any principled reason why you shouldn't have affirmative action programs specifically targeting those group of people, as opposed to, so to speak, those minorities that you normally think of in relation to affirmative action. And finally, with regard to effectiveness, I think, and whether there are any empirical data on this in connection with the book. I'm not an empirical scientist, so I wouldn't be an expert on this by any means. But from what I read when I wrote my book on affirmative action, my impression is that, so to speak, the empirical evidence on this is quite mixed. So India, for instance, has had a affirmative action program for low-caste people over a long period of time, I think since independence and perhaps even before. And while generally the literature suggests that this has actually improved the condition for Dalits who would probably otherwise not have been hired as civil servants, it hasn't been a miracle cure in the sense that you still have the ideology of caste in India. And I think in terms of Western Europe and affirmative action for women, I think that has actually made a difference in terms of representation of women. But it's very hard to tell, and that was the other point I wanted to bring across in relation to the empirical question, that it's very hard to tell because it's very hard to tell how would the representation of, say, women in Western Europe in parliaments or among CEOs or company boards, what would that have looked like? Haven't there been affirmative action policies? So these were some reflections in relation to the three questions. Thank you.
Muchas gracias, Professor
Thank
Zaba.
you very much, Professor Saba. Thank you, Diana. Those were great questions. Obviously, we can't answer specifically, only some reflections. With respect to the first question on how to prioritize resources, especially in contexts like Latin America, where the economy is not doing very well most of the time, and we have many people who are poor, and many of them live in structural poverty. So I could say that I couldn't associate affirmative action with resources necessarily. So the state can't, well, I'll go back to something I said in the beginning of my presentation. We shouldn't think about affirmative actions. Let's think about them in a broader way of preferential treatments, whose purpose is to dismantle structural inequality situations. If the affirmative action is part of this broader class of preferential treatment, we should not only think about distribution of resources. There can be regulatory strategies, for instance, to favor groups in structural disadvantage. But since these are regulations that treat one group better than the other, to justify those regulations, it needs to be founded on a justification, for example, of equality. I can think of two examples of situations of preferential treatment with respect to the distribution of resources or regulations in our region, without being targeted exclusively to structural poverty, they are linked to the intersectionality or situations in which there are disadvantages because you belong to different groups. I'm thinking about access to education. In Brazil, I don't know if this is still in effect with that gentleman who is president, but there are policies of affirmative actions, for example, in the access to universities that gave a preferential treatment to those who graduated from public high schools. Why? Because although it isn't an affirmative action policies targeted to Afros or people in structural poverty, it was possible to detect that in the admission to public or private universities, the admission of people who came from private high schools was significantly higher than those who came from public schools. Why? Because generally, Afro-descendants went to public schools or poor people. So we can think, what are those strategic nuts like the access to education to dismantle structural inequality that are not related to a specific aspect of the person or belonging to a community or group, but several. And I think that education policies could be one of those priority policies that are not necessarily policies for the distribution of resources. We're not putting money or public resources, but rather with regulations, we are seeing how access to university works. Something interesting as well is territorial segregation. The segregation of groups in our urban centers. What can the state do to not contribute to continue with this territorial segregation? Well, we have to see the situation in each one of the cities, but in many cities, groups who are in a structural disadvantage due to their race, for instance, are also concentrated in territories. And the state can do some things that contribute to this to continue, like design a system to access housing that builds houses in a marginalized area of the city. So those people in structural disadvantage may live there. So the state is producing this territorial segregation that in turn contributes to structural inequality of people who live in those houses. It's very complex. Of course, we are not going to solve this here, but I can give you some clues on how to address this. The second question, equality for what, or equality on what? I think most of my presentation had to do with that question, so I'm not going to explain a lot. So when we talk about equality with respect to affirmative action, we are talking about the mandate, constitutional mandate, and conventional mandate of dismantling structural inequality situations. So affirmative action is a mechanism to dismantle disadvantages or structural inequality. Regarding empirical data, lawyers say there are some evidences that we call diabolical, because when we are forced to test something that didn't exist, it's very complicated. You can prove something that existed. You can prove a homicide if we have a corpse, but proving something that did not exist is complicated. Legally, we reject this evidence because it's an impossible evidence. Now, how can we demonstrate that if there's no affirmative action, we would obtain better results? Or how can we demonstrate that the affirmative action produced better results? But I can mention some measurement models that are less quantitative and less verifiable in quantitative terms, but counterfactual, they are reasonable. I can't imagine how a Latin American parliament can discuss abortion without having women in parliament. That is, if there haven't been affirmative actions that make possible the parliament to be formed by a diversity of members, I wouldn't think that we would have legislations to protect the right of women. And even in mid-20th century in Argentina, women didn't have the right to vote. So how can we imagine that there can be decisions that benefit women if women are not part of that decision-making process? So I think that the evidence will be targeted that way, and maybe not through empirical measurements. That's very difficult to attain. Very well. Thank you very much for those thorough and generous answers. I'm going to make a second block of questions. Someone in the audience said that they know the distinction of Professor Lippert-Rasmussen entre prioritization and egalitarianism. So the question is for both of you. They want to know what's the place of economic inequality in your proposals. Does it have a moral value or a justification weight, or is it a more instrumental weight? And if what you defend is an egalitarian approach in terms of resources, economic status, or if you think it's better to have a proposal that prioritizes, that points to prioritize people who are in worse conditions and not necessarily make them equal. That's the first one. The second one is, well, all of them are interesting, but I think this is very interesting, and it's that affirmative action in other than the distribution of resources, if it's possible to think about an affirmative action in the criminal realm. So do you think if the typification of femicide can be understood in some sense as an affirmative action, specifically for criminal policies? And the second one is the scope and the ambition of affirmative action measures. The public asks that in the context of constitutionalism that is transformative, it's based on these ideas. Is this a problem of a gap between the ordered measures and their implementation? So the idea is transformative constitutionalism wants to change unjust situations, and we have these historical situations, but there's a big gap between what is ordered and what is done for several reasons due to capacities, etc., whatever. So these people ask, how broad should affirmative actions should be, or how ambitious? Is it preferable to have more calculated, more targeted and limited actions so that the control of their implementation and their effectiveness, however it is measured, is more feasible? That's the second group of questions. Well, let's continue with the same order. Professor Lippert, you may start.
Okay, thank you. Very good questions. In relation to the first one about economic equality, which I think probably covers some of the one of the questions in the first round, which I didn't really respond to. So the question is, does economic inequality or economic equality in itself have a moral value? Then my response to that question would be that I think that economic inequality as such is not non-instrumentally of a concern. So I mean, if people have different amounts of money, but then they are also unequal in other respects, such that those people who have a lot of money are disadvantaged in other respects. So they have to spend a lot of their money on addressing some of these other disadvantages. Say they might be disabled or ill in certain ways. Then even there's inequality of economic inequality. There mightn't be inequality in terms of welfare or in terms of resources overall. So my view would be that when it comes to what justice is basically about, it's not at a fundamental level about equality in terms of income or wealth. It's about equality of something else. And I think I would actually say, but I know this is controversial, that I think basically equality is about our living equally good lives and about our relating to one another as equals. And to the extent that we can achieve those two aims to the extent that we can achieve people relating to each other as equals and people living equally good lives, despite the fact that there's economic inequality, then we probably shouldn't worry so much about economic inequality. But don't misunderstand me. I'm not saying that we shouldn't worry about economic inequality, because as a matter of fact, I do think that if there's economic inequality, and especially if there's soft quality we find in, I think, most countries in the world, then that will definitely translate into difference in terms of how well people's lives go and in differences in terms of whether people can relate to each other as equals. So I do think we should be very much concerned about economic inequality, but not because it's of importance in itself, but because it affects things that at a fundamental level are important. And also, it might be hard to address through legal means whether people live equally good lives. I mean, whether people live equally good lives depend on a lot of factors that are very hard to regulate by law. I mean, one thing that's very important are personal relations to friends and family. And though law might affect that, it's very hard to use law as a precise instrument to address that. Whereas it is much easier to use law, say, to distribute income or wealth. So I hope that perhaps says something in relation to the first question about economic inequality. In relation to the second question, and I might have misunderstood what that question exactly was about, but I took it that part of the question was whether one could imagine extending affirmative action to criminal law or penal justice or something like that. And in response to that question, I do think that you could imagine various schemes that would involve affirmative action in those contexts. Again, this might be limitations in my knowledge. I'm not sure that this really has, that there are many programs of that sort. But suppose, for instance, that, I mean, one big problem is that when people spend some time in jail, that's not the first time that they spend time in jail, many people recidivate and end up spending more time in jail. And to the extent that the state can do something to prevent or encourage people to from recidivating, say by giving them training while in prison, then you could imagine, I would suppose, affirmative action programs where you target groups that have been, so to speak, to put things in Professor Saba's terms, if there are certain groups who have been subjected to structural injustices and for that reason are particularly vulnerable when it comes to recidivating, you could imagine the state spending a larger proportion of resources on resocializing or educating people from that group in prison. So I guess it's less popular in the criminal sphere than in other spheres because other values are salient in that sphere. But I don't see why one couldn't extend affirmative action to the criminal sphere. Whether it's a good idea to extend it to the criminal sphere, that's of course a different question. And one thing to take into account here would be whether in answering that question, we should, so to speak, keep whether we should, so to speak, base our answer on the likely responses in the wider public to such affirmative action schemes. Say it might be, that's just a conjecture on my part, it might be that in the wider population, it might be very unpopular if the state were to have affirmative action program in the criminal justice sphere, and that would lead to unfortunate consequences if you try to implement an affirmative action program, which is very unpopular among the wider population. But you could also say that, well, one thing that one should ask about here is whether that sort of negative reaction to affirmative action in the criminal justice sphere are justified, and then instead answer the question of whether it would be a good idea to have affirmative action in the criminal sphere on the basis of whether this would have good consequences on the assumption that the wider public, so to speak, responded to those programs in the way they should respond. So I hope this is a sort of response to some of what was in the second question, though I suspect that there was more to it than I've been addressing here. I'm sorry about that. Thank you.
Muchas gracias, Profesor Saba.
Thank you, Professor Saba. Yes, I was connecting. Yes. I could say, with respect to the first question, whether the thesis I propose is based on an egalitarian theory. I think I would be careful of not thinking that all the theses can be used for everything. Theses are applicable to all assumptions. There was an Argentinian philosopher, maybe you know him, Genaro Carrillo, who said that you don't eat soup with a fork. There are instruments that are useful for some things. So the idea of equality that I presented, and that is behind the justification of affirmative actions that I tried to defend, refers to a specific problem, that is structural inequality and the social structure of case. It does not necessarily have to do with inequality in the access to resources, but it might have to do with an aspect of the inequality in those resources. So the equality in resources or the access to a minimum of resources is not the main issue of structural inequality, but it can be that the groups in structural disadvantage are groups that have an economic structural disadvantage. That is, I would differentiate poverty situations and even extreme poverty with structural poverty situations, or poverty associated with, for example, the race of the people or the sex of the people. So I would say my first reaction would be, in that scheme proposed by this question, I think I'm more for a thesis that does not only take into account the access to resources, but structural poverty that, of course, can be affected by economic inequality. If the affirmative action is targeted to people of a certain race that for generations have been suffered structural inequality, I dare to say that they are also part of a group that is in economic inequality. So implementing actions for that group to overcome that situation, it also has to do with the access to resources. And what's interesting is that this position with respect to the responsibilities of the state with respect to structural inequality are different to the responsibilities of the state in the access of resources that underlies the idea of social rights, for example. The idea, the recognition of social rights like education, health, and the access of everyone to a minimum amount of resources for their health and education, etc., is a state responsibility associated with this idea of equality in the access to resources, but not necessarily to structural inequality. Maybe there are people who don't have access to healthcare and they are not in a structural disadvantage. I don't know if it's understood. These are two different problems. Sometimes they are intertwined because sometimes people with a structural disadvantage do not have access to healthcare. But I think we have different conceptual instruments to address different problems. With respect to criminal law, this is quite interesting. I'm not criminalist, but I've thought about this relationship between preferential treatment and criminal law. It's interesting, the example given by Professor Lippert. I haven't thought about it. If the state could justify channeling more resources in the resocialization of people who committed a crime and they are in a structural disadvantage. That's a good question, indeed, as Professor said. If that has consequences, well, we are talking about the justification of the policy. The policy could be justified. I was thinking about, once again, the resources, but rather the preferential treatment of the state when they apply criminal law. Someone was talking about femicide. It's interesting because femicide gives a treatment to certain behaviors if the criminal behavior is targeted to a woman than to a man. So someone might say this is inadmissible in terms of equality. Why are we protecting, quoting, women? Because women are victims of structural violence. Violence against women is a problem in many countries, in Europe and Latin America. It is a problem that affects women. Okay, so the state could apply a differentiated policy for male and female victims. This was said by the Inter-American Court in one case. The responsibilities of Mexico for this group that is victim of structural violence in Ciudad Juárez requires a state that takes specific measures for that group. Some have to do with criminal law. I have another example for you. In the cases of human trafficking, as I've discussed with some lawyers, some problem of criminalists or criminal lawyers is that they always face the autonomy of victims to accept the situation in which they are, subordination, violence, submission, etc. Well, criminal law that is aware of the situation of women that are usually victims of sexual violence could rethink the notion of autonomy that is behind of those behaviors that should be assessed if they are a crime or not, from the perspective of the situation of that specific group. Maybe ask a victim of trafficking if she decided by her own accord to be trafficked, when that person who trafficked her took out her passport and abducted her. But, well, you can say, well, she accepted to work at the service of this person. No, no, no. I think the criminal law could incorporate, and this is an hypothesis, and I've talked to other lawyers, we could incorporate the notion of structural inequality for the criminal law to respond differently before situations or crimes whose objective is, or whose target is a group in a disadvantageous condition. With respect to the last question about the scope and the ambition of affirmative action and the transformative aspect, if it needs more specific mechanisms, I'm going to give you a generic answer. I think we would have to see this with a concrete case. And it is true that for those of us who think that there's a transformative constitutionalism, that we can interpret our constitution according to these values envisaged in the constitution, like equality, it is true that when we apply these ideas to concrete ideas or specific policies or litigation, they not always turn out well. So we have to see which strategy is more appropriate. This idea that we can design a policy and it will have certain results, and it turned out it wasn't the case. We achieved the opposite. But also with respect to this criticism or that objection, I wonder, and what's the alternative? Not doing anything? It's true. Maybe the strategy leads us to undesired results and even contradictory results. Of course, we have to improve the strategy, but I don't think there are many alternatives. Yes, maybe we have to try, but we don't have many options left. Thank you very much, Professor Saba. We are getting to the end. We only have 2 minutes, so I'll try to group the questions about stigmatization, maybe in 1 or 2 questions. It's a shame that I cannot ask the other questions, but I'm sure we can discuss them later. With respect to stigma, some people ask if these actions, beyond stigmatizing people, could contribute to more actions of violence and discrimination from dominant groups and sectors. So they are concerned about privileged groups if affirmative actions question their privileges and the possible effects or consequences on discriminated populations or populations favored with affirmative actions. And the second one is beyond the stigmatization. Well, something very important is the type of society where stigmatization takes place. At least in the discourse, people defend this meritocracy, whether it is true or not, whether we have case or not. At least in Latin American society, the idea of meritocracy is a valuable idea with a lot of strength. So in this context, the stigma would be very difficult to overcome for people who are beneficiaries of affirmative actions, because we don't have the assumption of the merit, but rather the this help. So in these few minutes, I would like to know what you think about these two questions. Professor Lippert.
Okay, so given that we don't have that much time left, I suppose my answers should be rather short. So in response to the first question, actually that connects to what I mentioned in my talk about whether we're talking about ideal or non-ideal justification for affirmative action. Because note that, imagine you have a group of privileged people who will respond violent to affirmative action in favor of a group of underprivileged people. And imagine they saying, well, if we have implement affirmative action, we will respond violently against members of your group. Therefore, we shouldn't implement those affirmative action schemes out of a concern for you. Then the obvious response would be, well, you shouldn't be violent against us just because you implement this affirmative action scheme. So I think, I mean, that's a kind of dialogue that won't take place, of course. But what it shows is that it might turn out that it might show that there's a kind of non-ideal or pragmatic reason not to implement affirmative action in those situations, which I think is a real worry. But it's not an argument that can show that it would be unjust to implement affirmative action in those situations. So that's in response to the first question. In response to the second question, it's kind of related to the first question, actually. But I think it's very important here to be aware that different groups are stigmatized to different degrees, and some divergences from the ideal of meritocracy might not be seen as such if we're talking about a privileged group, whereas other divergences might be seen as such if it's a non-privileged group. So here's a case from Denmark. So in Denmark, women tend to take more parental leave than men do, and that gives men a competitive advantage on the labor market, because employers know when they hire women who they statistically can expect to take parental leave, they would take parental leave for a longer period of time than men do. Now, suppose that you have, so that gives men a competitive edge. Suppose you have an affirmative action program in favor of women that gives women the same additional competitive edge that this fact about differential patterns of parental leave give men. In that scenario, I'm certain that women will be stigmatized as this is a diversion from the ideal of meritocracy, whereas I've never heard any people raise the complaint that he just got the job because he has this statistical advantage that men tend to take less parental leave than women do. So I think what that shows is that, true, we need to worry about this issue about stigmatization, but in relation to meritocracy, the ideal is used in a very selective way, favoring particular groups. So I hope this responds to some of the things in the second question.
Yes, thank you very much. Is it my turn, Diana? Yes. Well, trying to be very brief, with respect to the first question about stigmatization and possible consequences or reactions. Well, yes, there can be, and not only against affirmative actions, but against any decision that affects any privilege or advantage situation. When you were asking the question, I was remembering when the Supreme Court of the US decided that racial segregation is contrary to the equality in the law. And the first Afro kids went to school with white predominance. You might remember the pictures of those moments. There's a famous picture of an Afro girl. She was 8 or 9 years old. She was accompanied by the police. And there was a mob shouting and attacking her because she wanted to study in a school for white people. We're not talking about affirmative actions, but a decision that says that segregating races, like it was an apartheid in South Africa, is not consistent with equality in the law. So we can have reactions for sure. And no one said that we can achieve this without this type of reactions. Now, I think that when we think on preferential treatment measures or affirmative actions, maybe the state has to look for strategies to produce the least negative reaction as possible. That is, here we would have to talk about specific measures, but the state not only can oblige, but also persuade and generate incentives. I'm thinking about debate of women in boards. In some states, I think it was Spain, the state didn't oblige women, the companies to incorporate women in their boards, but they only took this measure every year. They ask the companies, how many women do you have in your boards? And they ask, why don't you have more women in boards? Asking that question increased the number of women in boards. So I think we can achieve the same objective with means that produce less reactions. That doesn't mean that we don't do everything we have to do, but we could think about the tools we have: incentives, persuasion, justifications. So the judiciary is very important. Of all the branches, it is the one that might better present the justifications for these measures. So I think that could help for the effectiveness of these measures. Look for alternative mechanisms. With respect to meritocracy, well, I think that's a false argument. We lawyers know that if you can frame a discussion, you have won half of the discussion. I say, we are discussing this, I already won half of the discussion because I framed the discussion. So I think that discussing whether the action is like that, well, this is not a good way to face affirmative actions and meritocracy. There's a lot of evidence. Of course, there are grayer cases, but there's a lot of evidence that the lack of access of women to politics, to justice, to the boards of companies isn't related to the lack of merits. If 99% of the boards are formed by men, that means that across Mexico or Argentina, there are no women with enough merits to be part of the board of a company. So that's a negative test. Don't make me prove that. It's evident that you didn't look well. There's a bias in the selection of the members of the board. Those who invite people to be part of boards sometimes are men who know other men and they invite them to their boards. It's okay, that can happen, but there's no merit. I think that's a false debate. When the Pritzker Award for the best architects was given 30 times to men and only once to one woman, so no women deserve this prize. So I think the problem is not merit. No one is saying that affirmative action will put someone in a position and she won't be able to do their work. Or maybe a student or a professor that can teach well. No, we're not talking about that, but people with merits, no one can be left out for his or her race. This is what we are saying. Very well, thank you very much to both of you. Your time, you used just the right amount of time. And thank you very much for sharing your ideas this way in such a generous manner and for talking to us this morning about this important issue, but sometimes it's overlooked. I'd like to thank the people who were with us in our social media and the platform of the court. Thank you for your questions and of course, for your participation. Finally, I'd like to remind you that the next session of the seminar will be on Thursday, 21 from 9 to 11 a.m. Mexico City time. The topic will be quite interesting and there's a lot of controversy that is discrimination, indirect discrimination. Thank you to all the participants and the members of the table. And I hope we see you on October 21. Good morning. Thank you, Diana. Thank you, Professor Lippert.
Thank you very much.
Professor Lippert, Professor Saba, thank you very much for your time. It was a very rich conversation. We have a lot of debate based on what you presented. Once again, on behalf of Dr. Ana Maria Ibarra, we thank you for your interest and for your support to participate today. And we hope that in the near future, we may have you again with us. Maybe it can be a Congress, a forum, a course, because the court organizes different events and we'll try to have you. I also thank Diana, the interpreter, who was during this session. And without further ado, I thank you. Have a great day and good afternoon in Europe, and we'll be in touch.